finally had time to do a summary change, but she did it before.
I didn't, well,
We had it yesterday, I noticed.
yes, it did. All I did today, in response to some of the requests for information, I believe you got from Maine Associations of Substance Abuse Programs, you got a single sheet that gives you the scientific sources for some of the data that was provided to you yesterday. And I know that you got an email this morning with a number of the studies contained in it. The studies amounted to, I think, over 100 pages when you put them together. So Suzanne has not printed them for you, but you do have them electronically. And then you had asked a number of questions, and I don't have complete answers to those questions today, but I have some material that would be the starting point, or for some of you may be adequate. So I just showed you what you have on the green sheets. Page 1 is just sort of an index, a cover page. Page 1 is from Title 21 of the United States Code, the Controlled Substances Act, and it is the law on denial of federal benefits for drug trafficking and drug possession. I will not interpret this for you, but it does contain information on some of the exclusions from benefits that could apply. I did notice when I was looking at it that in the drug trafficking for first and second offenses, and in the drug possession for the first offense, and perhaps for the second and more, those are at the discretion of the court. And I also noticed that at the bottom in the definition of federal benefit, veterans benefits and public housing are excluded from the definition of federal benefits. So I guess what I would say is, reading the actual law here, we probably have more questions than, it probably presents more questions than it answers. We would have to have an expert here to help us with those. Okay. On page 3, I think Representative Garrett should have questions about employers. And on page 3 is the Medical Use of Marijuana Act, and in section 2426, subsection 2, it specifically says this chapter may not be construed to require an employer to accommodate the ingestion of marijuana in any workplace or any employee working while under the influence of marijuana. And then on page 5 is the Title 22, Section 2383 on possession of marijuana. This is the place in the law that sort of as a carve out makes possession of up to 2.5 ounces a civil violation. A civil violation is not a crime under Maine law, and you are not convicted of a civil violation. So that raises the question of whether in the federal law that we were just looking at, that talks about convictions, and this in Maine, this is considered to be a civil violation. It is not a conviction. But once again, I can't give you the definitive answer on what the federal law how it would read, because I don't know how they interpret it. On page 6 and page 7 we've actually spent a lot of time on section 1107A of Title 17A, and this is on page 7. You'll see where the Schedule Z drug possession of marijuana is a Class E crime for between over 2.5 ounces to 8 ounces, and then it goes up from there depending on the quantity possessed. Then the rest of it is employment law, and this is Title 26, which controls employers' use of drug tests, and this really is applicable to employment and employers' actions when an employee tests positive for drugs or refuses to take a drug test. There are specific requirements in the law for the employer to have a policy that is approved by the Department of Labor. So it is complicated, and the people that I spoke to in the office felt that there is not a difference. There is a difference between a person who is being interviewed to be an employee and an employee, but there was a feeling that there is not a difference between legal and illegal drugs in terms of what the employer can do. But there is a big difference between testing positive and coming to work under the influence of a drug. So that's that information.
Representative Powell?
Was that a difference, if it were made legal, there was a difference in being under the influence or coming to work under the influence?
I think there's a
difference between those two?
There's a difference between testing positive
Yeah.
and being under the influence.
If it were legal, there would be a difference. Or there
I
is
am,
currently.
I'm not qualified to answer that question, but no, I don't know.
Representative Joy?
Madam Chair, thank you. I was wondering why we had scheduled it the day after the hearing for a work session. I know we want to get our work done and everything. And we have two bills that mimic each other. I suppose they could both be considered together. But our analyst has brought up some good points here, especially some of them where she cannot help us, and also indicated that we need more information on some of the others. I hate to say this, but I would like to table both of these bills until we can get this particular information that we just covered for us, as well as try to contact the proper individuals that can answer those questions for us. Because I really, and I want to make a decision on this, but I really can't make a decision today. This is way, way too soon, especially what was just presented to us. And I feel bad for the analyst having to rush through this as she did, because all the work that has been presented to us in the past and currently has always been excellent. And I just feel that she's being rushed at this time to bring this information forward. So I would make a motion that we table.
I heard a rumor about an hour ago that this was going to happen, even before this information was brought up. And I feel like we heard hours and hours of testimony, and I don't think that this would make a difference. But Representative Powell?
So in my feeling on having a work session today, it was more to have our questions brought forward so that the analysts could have time to get information for next week's work session. It was more for us to put out there what we might need for information that while it's still very fresh to us to put that information out and have time versus waiting until next week and then putting the questions out and then waiting again. So it wasn't, I had, in scheduling a work session the next day, I had no intents thinking that we were going to be prepared to vote on something today. I really think we do need time to digest some information, some of us, and most of us maybe, especially the new members, mine being one of them on the committee, and to hash through some questions that we may have as a group that we want information on next week when we come back for another work session. So that was my thought.
Representative Warren?
Thank you, Madam Chair. I totally agree. I cannot support a tabling motion because I really want to work these bills. I have lots of questions and still digesting a lot of what we heard yesterday.
So today's the day for questions. If you have questions you want to bring up.
Thank you, Madam Chair. I'll repeat that I will not support a tabling motion today. My plan was to gather information. I have questions, and I was hoping we would work these bills traditionally.
Representative Babbitt?
Thank you, Madam Chair. Well, I'm still working my way through both bills line by line. It takes a while. Try and do some comparisons. I did get an email this morning that you probably remember the committee did getting a call who sent it. Made a comment, these bills are extremely important. And to rush into a work session, they have a public hearing without trying to rush it to a conclusion. It raises the probability that whatever we do is going to be fraught with error. I want to avoid that. I agree with Representative Warren that perhaps we can ask some questions this afternoon, get some answers, and then table for tomorrow and have another work session next week.
I think that's
Representative Joy?
I don't mind working it or anything, but I'm just saying that I'm not ready to vote on this today, and I'm not about to vote on it today. So I guess that's where I'm at. We also have to find the proper individuals or divisions that can answer some of these questions for us, which may not be today. So at the end, we may end up following through with what I suggested, but I don't mind working it. I don't mind asking the questions and everything. You know, I think that's a good direction to go in.
So I agree. I think we need to be able to have the questions asked so that we know who we need to have come into our next work session to answer those questions. So if anybody has questions that they want to put forward, so that we make sure we have the right people with us next week, I think that would be a good direction to head. Okay. Representative Warren.
Thank you, Madam Chair. Did I miss the analyst presenting?
Yeah.
I think Suzanne came to get, okay. I'm sorry. I have to be on both committees, so could you go back through what you presented? I think Suzanne forgot me and I was next door.
Well, the only thing I did was took you through the green papers, and I don't have more information than that. The real questions are employee, the rights available to, and procedures available to employers, and the question of federal drug penalties for convictions of federal and state law. And I would be happy to try to get people here next week on those two issues for you. And there's information in here, but I don't have information on how the federal government interprets the question of what's a conviction under state law. So I can't tell you. I know that in Maine, we do not consider an adjudication for a civil violation of possession of up to 2.5 ounces of marijuana. We do not consider that to be a conviction. That is an adjudication. I don't know how the feds view that, and that really was the question. So I'd be happy to try to get that for you next week. Other than that, I would refer you to the buff-colored chart that I did, that just taking you through it as an overview. I would say, let's come back to the front page. Below the front page are more traditional bill analysis of 1401 and 1380, divided into sections that talk about taxation, cannabis or marijuana possession, regulation, the state agency, various protections, food preparation, concealed weapons permit, and the youth prevention fund. Both mills cover pretty much all those same categories. So there's sort of a short version of the bills inside under the brown cover, and then on the cover sheet is an even shorter version that shows you the differences in the proposed taxation, the differences in the proposals on possession, on licensure and adjudication, and then a listing of some of the other provisions from the bill, notably that LD 1380 doesn't take effect until it is approved by the voters in a referendum in November 2016. That referendum provision is not in LD 1401. So I'd be happy to take you through the details of some of those tax, possession, licensure, regulation provisions if you would like. And I'd be happy to note down any requests for information that you have for next week and try to get people here.
Does anybody have any questions at this point? Representative Joy.
Thank you, Madam Chair. You mentioned that, I don't know if it's 1 and 2, that you weren't able to answer some of those questions and I assume we're going to have another meeting. Who would you suggest, and could you contact those individuals to come in?
Sure.
So that we can speak to them? That would not only be for 1 and 2, it would be for whichever one you had concern with.
Right. Well, the real issue, the two big issues, I think, are the question of employer procedures and rights with regard to employees or applicants. The Department of Labor could probably help us with that issue, and so I'd be happy to try to talk to them. Probably I would start with somebody from the Attorney General's office on the question of the effect of a federal conviction on benefits, but I might have to go to somebody from the U.S. Attorney's office from that. I don't know. It's fairly unusual for them to come to Augusta, so I would be happy to try to get you whatever help I can get.
Representative Warren.
Thank you, Madam Chair. So I'd like to hear more about how the process of these bills will guide what the referendum process is going to look like. So here's what we know in the state. What we know in the state is that these questions are coming on the ballot. So how can we do some work here to help guide those questions? And I heard some reference to that yesterday, so I don't know if somebody's here that can answer that question, maybe Dan Walker or someone else, but I really want to get a sense of how does the work that we do here together advise what we know is going to be on the ballot? How can we use our collective work to guide that process?
LD 1380, if you pass that bill, as one of the provisions of that bill is that it does not take effect until it is approved by the voters in November 2016. So if you, in the traditional manner, pass 1380, it will go out to the voters in November 2016. I understand that I think there is one initiated bill that has been approved through the Secretary of State's office that is, I believe, is out for signature.
Yes.
I don't know whether the other one has been approved yet by the Secretary of State's office.
Permitting or not, yes.
Okay. But neither one of those has been passed by the voters, so you don't know. You don't know.
So my question would be,
Just a follow-up, thank you, Madam Chair. Again, I would like to hear from somebody about how this process would affect the questions that are very likely to be on the upcoming ballot. Thank you.
Representative Russell, would you have please?
Thank you, Representative Diane Russell, sponsor of the bill. So, having been through numerous citizens initiatives and being in the process of 2 right now, let me walk you through this. So, per the Constitution, if there is a ballot referendum that has been approved and certified by the Secretary of State, meaning that they have gotten their signatures, at that time, which will probably be, certifications usually, the deadline to turn in the ballot initiative signatures is usually January of 1 year. And then by somewhere in the middle of mid to late February, the Secretary of State will come back and certify whether or not those that petition has gotten enough signatures to qualify, which is somewhere in the neighborhood of 61,500. So if at that time next year, when 1, if not 2, of the ballot initiatives come before you, you will only be able to vote on those initiatives up or down. The third option is to do a competing measure. Now, the question is, are you going to do a competing measure on the first ballot initiative, are you going to do a competing measure on the second ballot initiative, or does it, by the Maine Constitution, require that ballot, whatever competing measure you do, to be put on both of those initiatives? So there will be 2 initiatives on the ballot. Do you support legalizing marijuana? Do you support legalizing marijuana if both of them get there? Now, they both have 2 very different approaches to legalizing marijuana, at which point, if they both pass in November 16, we're going to be right back here again in January of 2017, and you're going to have to determine what the voter intent was. So we're going to be in a bigger mess later on. Now, if you pass a piece of legislation now, the Marijuana Policy Project has agreed to not be collecting signatures. I can't speak to Legalize Maine, and we will put that ballot, the question is up to this committee whether you want to put it on in 15 or 16. I personally think 16. There's some folks that would like it done sooner. But irrespective, this is the last chance that you have to be able to do something and to guide that process, like you said. So the bills have been written already and presented to the Secretary of State. There's no changing those initiatives now. But these bills that are before you, this one and 1401, are in your hands to shape. And like I said, you know, you can go through the differences of the bills, but as you can see here, they're very similar. So if you were to merge them into one, you would actually be able to then put that question to the people the way that you'd like that question asked. So does that provide a more thorough answer for you, Representative Warren?
Thank you.
But you could end up with 3 on the ballot if you set a 1380 to the, if you pass 1380, it goes to the ballot also.
Well, if you pass 1380 today, and then the other 2 initiatives choose to continue to collect signatures, there is very much still a question, I guess, as to whether or not those were considered competing measures. I think that's a question for the Secretary of State. And if they were competing measures, then they would potentially compete with both initiatives. So you'll have both initiatives on the ballot, then you have a competing measure that competes with both of them. So it'll be question A, B, or C, yes, no, or none of the above. Or no, you'd want, I prefer this option, and then none of the above. But, as I said before, for certain, the Marijuana Policy Project has agreed not to collect signatures, so it would be in that position. I can't speak to Legalize me.
Is there any technical problem with us doing something that's a competing measure in the legislative body? That we be working on something that is also being petitioned outside the House? Is that a conflict also, or a competing measure that we as legislature seem to be concerned about?
And that comes down to, so you can work on it now and pass it because neither of those initiatives have collected their signatures or been certified. The question is a Secretary of State question, and I don't know the answer to this one, which is what happens next year if one of those initiatives does collect signatures and get on the ballot. And I don't have an answer for you on that one. But yes, you can do what you're doing now because the initiatives have not been certified as complete. There are countless initiatives that